Right. Our my clock says 12:02, and we are going to unfortunately have to keep our program to exactly an hour today. So I am going to go ahead and get us started as soon as I admit these last two people. Okay. Hello, everybody. Good afternoon, and welcome to this special pre-Martin Luther King Day event hosted by the Evanston History Center. I'm Eden Giron-Perlman, Executive Director of the History Center. Welcome to everyone. Before introducing our speaker, I'm happy to announce that our new season of Under the Buffalo Lecture kicks off next month. Sorry, I'm doing a little admitting of people, so I'm going to focus just on introducing. Kicks off next month. We have a great lineup this season, beginning with Brian McCamick, who will discuss his book, Landscapes of Hope, Nature and the Great Migration in Chicago, the first major history to frame the Great Migration as an environmental experience. We hope that you will join us for that event and others in the series. More information on registration is available on our website, evanstonhistorycenter.org. If you are an annual member of the History Center, thank you so much for your support. And if you're not a member, I encourage you to become a member. Not only will you support free programs like this one, but you can also attend others for free. And we'll post a link to our membership page in the chat. And now, today, we are in for a fantastic presentation. We're so happy to welcome our speaker today, Kate Masur, Professor of History at Northwestern University. Kate specializes in the history of race, politics, and law in 19th century United States. She is the author of numerous books and articles, including An Example for All the Land, Emancipation and the Struggle Over Equality in Washington, D.C., and with Gregory Downs, The World the Civil War Made. Masur's scholarship has recently appeared in the Journal of Civil War Era and the American Journal of Legal History, and as a commentary in the Chicago Tribune and the New York Times and the Washington Post. She is with us today to discuss her most recent book, Until Justice Be Done, America's First Civil Rights Movement, From Revolution to Reconstruction. Until Justice Be Done is a groundbreaking history of the movement for equal rights that courageously battled racist laws and institutions, Northern and Southern, in the decades before the Civil War. The New York Times called her book a powerful new framing of America's first civil rights movement. Not only has Kate's book served as an instructive, eye-opening, and inspiring work for all of us here at the History Center, but has also prompted us to create new educational materials for educators that draw upon Until Justice Be Done. And connects with local Evanston history. These materials are available to everyone for free on our website. We will post a link to the materials in the chat. Special thanks to Nina Barrett, owner of Evanston's local bookstore, Bookends and Beginnings, for partnering with us on this event. Nina has been an amazing partner on so many of our events, and we are deeply appreciative of her friendship and support. We'll post a link to Kate's book on their site if you'd like. You can order directly from Bookends and Beginnings. After the presentation, we'll have a Q&A. If you have questions, please use the chat feature and type your question there. We're also going to try something new for this event. If you'd like to ask a question live, please let us know by raising your hand. The raise your hand feature can be found in the reactions section below. Then you can unmute your microphone and join us during the discussion. Again, thank you all for joining us, and thank you, Kate, for being with us today. And now I will hand it over to Kate Masur.
Hi, thank you so much for inviting me to present here. It's really a pleasure and an honor to do this. And I'm not only a professor at Northwestern, but also a resident of Evanston and parent of kids in Evanston public schools. Well, only one now because one graduated from ETHS. So I feel really connected to our community, and I see a lot of familiar names here at this talk. So it's really a pleasure to be here. I'm going to share my screen and use a presentation for this talk, and hopefully we will have no technological problems. Maybe that's too much to hope for. Okay, so it's really wonderful to be able to talk about this book here. My new book is called Until Justice Be Done, America's First Civil Rights Movement from the Revolution to Reconstruction. And one of the fun things about working on this book was that more than I anticipated when I got started, this book ended up being about the Midwest. Now, it's not exclusively about the Midwest. There's a lot in the book about actually Black sailors who lived in places like Boston and New York City and Philadelphia, and a push for civil rights on their behalf and by them that took place in a different kind of venue from the events that I'm going to talk about here. But in today's talk, I'm really going to focus on the book, the material in the book that's directly related to the history of the Midwest, particularly Ohio and also Illinois. And I'm really going to spend some time going into Illinois because here we are in Illinois, and I think this is a history that many of us could know better and could think about. And I'm really grateful too for Jenny Thompson at the Evanston History Center, who has been working on bringing some of the material in the book into conversation with the history of Evanston itself and putting it together as materials that teachers could adopt in their classrooms. Okay, so I'll start with a petition. This was a petition produced by a political convention of African Americans in Ohio. The convention met in Columbus in July of 1837. And the main purpose of the people who gathered there was to devise a strategy for repealing the racist laws of the state of Ohio and securing funding for the education of Black children. The group came up with a petition that called on the state House and Senate to repeal what were then known as the Black laws. These were laws first passed in Ohio in 1804, immediately after Ohio became a state, that required Black residents to register their residency with local officials and barred them from testifying in court cases involving white people. The laws also provided public education to white children only. In this petition, the group pointed out that Black Ohioans owned property and paid their share of taxes. The petition concluded with the following words, and this is at the bottom of the petition. You might not be able to read it, but this is how they wrap up the petition to the legislature for repeal of these laws that targeted Black residents only. Your petitioners feel bound as men, Christians, and Republicans to humbly urge this subject upon the attention of your honorable body, and from the exercise of this inalienable right of freely expressing our opinions, they can never cease until justice be done. Now, this petition gave me the title for my book, obviously. But I like this phrase, until justice be done, because what they're saying is in committing themselves to continuing to petition and to fight until justice be done, this group said something important about what I've called in my book, the first civil rights movement. So in the book, I describe a substantial, wide-ranging, and consequential debate about race and civil rights in the free states from the late 18th century through the Civil War. I show that throughout this period, and particularly from the 1820s to the 1850s, a broad-based movement for racial equality in civil rights emerged and made significant headway in Northern politics. The most consistent and dedicated people in this movement were Black Northerners, people like those who gathered in Columbus in 1837, who from the beginning rejected racial discrimination. These Black activists pushed their white neighbors and white lawmakers to view questions of race and inequality in a new light. And although many white people were indifferent to this issue or opposed, they wanted the Black laws to continue, some in fact came to support goals like repeal of the Black laws in places like Ohio and Illinois. They brought these claims into party politics, from which African Americans were largely excluded. And eventually their views became part of the political mainstream, part of the Republican Party. Now, if you have not heard of this civil rights movement, or if you've never thought about it in this way, you're not alone. We have often failed to see this movement because we're focusing on other things. In history classes, for example, we often talk about abolitionists and the great pre-Civil War debate about slavery itself, about the causes of the Civil War, the question of the extension of slavery, who the abolitionists were, the theories that they used to oppose slavery. Some historians have also written about the history of Northern Black communities here in Illinois and in other places in the North, in the Free States. But I think what we've missed overall was the existence of this really broad-based struggle over the rights and status of free African Americans and the Free States. And this struggle was interesting in its own right, but it also had an impact on federal legislation, on the first federal civil rights measures, the 14th Amendment and the Civil Rights Act of 1866. And I'm going to come around to those measures at the end of this talk. So a crucial point here is that the northern states were in many respects post-slavery societies. And I think that's how we should think about them. At the time of the American Revolution, slavery was legal throughout British North American colonies. As northern states moved to abolish slavery, their free Black populations grew and were augmented by people who migrated northward from the slave states in search of a better life. What ensued then in the Free States was a debate about what a post-slavery world should look like. And in this context, many white Americans insisted that there was no place in this nation for free African Americans, or really for any free people of color. These folks argued that free Black people should leave the country, and this was what's called the colonization movement, the idea led by prominent white people that you could have a country that had enslaved African Americans or enslaved Africans, and you could have free white people, but the category of free Black people was too problematic. It could never really work. And so the colonization movement, which involved people like Chief Justice John Marshall of the Supreme Court, Thomas Jefferson was a supporter. These folks argued that there should be a way to have free Black Americans leave the country and form their society. In many cases, they argued in Liberia. And actually, the American Colonization Society formed a colony in Liberia as a place where free Black Americans should go. And these same people who thought there could be no place in American life for free Black people also were the kind of people who passed laws like the Ohio Black laws and the Black laws of Illinois and other northern states as a way of signaling to free African Americans that they were not welcome here. So in this context, in some ways, what's surprising in a context in which enslavement of people of African descent was widely accepted, and which the right of white settlers to land occupied by Native Americans was also often taken for granted. What's surprising is not so much that white people supported racist policies, but that some of them, and in fact, across the first half of the 19th century, growing numbers of them came to reject racist policies and demand something better, more equal. So the people who participated in the first civil rights movement addressed the problem of racist public policies from many different perspectives, and they didn't always agree. So this was not this movement was a coalition. People came at it from different perspectives, and they weren't always in agreement with how far their demand should go. But they did come together around one important idea, the idea that a multiracial society composed of free people was possible, and that when it came to civil rights, laws that drew distinctions based on race were unjust and un-American. And as I'll describe today, these folks, this movement made significant inroads into American politics and are in many ways responsible for the first federal civil rights statutes, as well as the 14th Amendment. So that's kind of the context and the overview. I want to go back to basics for a second and talk about the US Constitution, which is something I'm always really interested in. So you might wonder how it was possible to have state laws in the free states that blatantly said things like, and this is a quote, "No Negro or mulatto person shall be permitted to emigrate into and settle within the state unless they had two landholders to post bonds for their quote unquote good behavior, and that any person who did not comply could be removed immediately from the county." So this is from the Ohio law. So was it constitutional to have laws like this? Would it be constitutional now? And I think as we focus, as many people are focusing on the teaching of American history and what is the Constitution and what did it really give to us, I think it's important to be clear on this. These racist laws in the free states were entirely constitutional at the time of the American founding under the Constitution that existed from the founding until the passage of the 14th Amendment. So let me explain. In the years between the American Revolution and Reconstruction, there were few limits on states' power to infringe on individual rights. And this was a profoundly unequal and hierarchical society. State governments could decide who was a citizen of the state. They decided whether women would be permitted to keep their property when they got married. They decided, state governments decided whether to institute slavery. They decided whether to prohibit people from voting based on race, gender, age, or wealth. And they decided whether to make people who they considered paupers or vagrants deportable. They also decided whether to restrict the basic civil rights of free people based on their race. Okay, so state governments could do all of these things with no limits, with essentially no limits on their power. And very few people believed that any of those policies that I just mentioned violated the Constitution. So because states had so much power over individual rights, many of the battles for racial equality in early civil rights were fought at the state level. People needed to persuade state governments to change their policies, and there really was no channel for getting the federal government involved. So now let's take a look at some of those state level struggles in this first civil rights movement, focusing on the Midwest. This will be familiar to many of you, but the Northwest Ordinance established the geographical region that we now know as our region of this part of the Midwest. The Northwest Ordinance, passed in 1787, declared that slavery was outlawed in this whole territory. Now, slavery already existed here. The French had brought enslaved people here, in some cases enslaving Native Americans as well as Africans. The British had continued the practice, and early after American independence, there was also slavery practiced here in this region. But the Northwest Ordinance pretty much set slavery on a path toward extinction in the region. Even although some people tried to stop that from happening. Okay, but even though slavery was outlawed, beginning with Ohio in 1804, the states and territories of the Old Northwest adopted laws commonly known as Black laws that, as I mentioned above, required Black residents to register with local officials, get other people to post bonds for their good behavior, and carry evidence of their freedom wherever they went. These laws also prohibited Black people from testifying in court cases involving whites, and they barred Black children from public schools. Separately, by state constitution, these states prohibited Black men from voting. And the cartoon that I have up here I like to show this because this indicates a kind of critique of the laws. Well, I'll get to that in a second. So these laws generally these Black laws enjoy great legitimacy. Why was that the case? Well, first, many white Americans did not see free Black people as their equals or as fully vested members of their communities. They just were, they were just racist. They really just did not think that Black people could be part of the community that these white people thought was naturally supposed to be a white community. And they thought that the states were fully entitled to determine the status and rights of their residents, including by drawing on what contemporaries called the police power of the states to impose regulations on people thought to be threatening to the public peace or the common welfare. So states and municipalities regularly used their police powers to do all kinds of things that regulated individual rights. They created fire codes, they regulated slaughterhouses. And police powers are actually still really important in how regulation gets talked about. So for instance, when you do something that's in the name of the public good, like require masks in certain places, that's using the police power, right, of the government. And some people think it's a violation of their rights, and other people think in certain situations that the public peace or the public good needs to trump certain kinds of individual rights. So the police powers has a long history of the idea that part of what governments do is act in the name of the public good. But of course, what is actually in the interest of the public good, as we well know right now, is often very debatable, right, up for debate. So in the period that I'm talking about, states use their police powers. Again, the idea that we are acting in the public good, and within that, poor law principles inherited from England to decide whether poor people who were newcomers to their communities would receive relief or be involuntarily expelled and transported back to their place of origin. So there are all of these laws inherited from England, really long-standing laws about how you can actually deport poor people and vagrants because they are considered threatening to the public peace. And you do that using the police powers of the state. So what I found in my research that was particularly interesting to me was that the racist residency laws of states like Ohio and Illinois were built on top of these poor laws and were examples of using the police powers. So the Ohio law, for example, said, quote, Negroes or mulattoes who violated the registration laws could be removed immediately as required in the case of paupers. And you see over and over again that they're merging ideas about race with ideas about poverty in order to justify these laws. So states north of the Ohio River, Ohio, Indiana, and Illinois in particular, passed laws like this and repassed them and updated them, often in response to new policies from passed by adjacent slave states, which in the 19th century were placing growing restrictions on free Black people. So legislators in places like Illinois and Ohio worried that Kentucky or Missouri would pass such stringent laws against free Black people that they would drive those people into the states north of the Ohio River. And they argued for tightening the laws, saying that Black residents would be an undesirable population, similar to paupers and vagrants, that they would become dependent on public resources and a threat to public peace. So that's where, let me just say one thing about this cartoon here. So with all of this discussion of the idea that Black migrants into the state are going to become dependent and threatening to public peace, you have this cartoon that's going in the opposite direction, that's saying that's a ridiculous argument. And pictured in the cartoon are a group of African-American men in the foreground working really hard. They're doing carpentry. One guy is shoveling. In the background inside the house, you see a Black woman who's doing laundry. And then you see a well-dressed white couple off to the left-hand side, and they're walking by and they're saying, poor things, they can't take care of themselves. And so it's a commentary on how wrong it is to argue that African Americans in the free states are going to become dependent, are going to be disruptive. They're saying, look, it's so ridiculous. It's right before their eyes that the people are working hard, that they're not disruptive, they're not threatening to the public peace. But this was an argument that people had to make many leading legislators, and the states themselves were passing these laws over and over again that restricted the rights of free African Americans and were designed to discourage them from moving into the state. Okay, so what I really am writing about in the book is the movement to repeal these laws at the state level. How do you create a movement to get rid of policies that are wrong, that are abusive, that are discriminatory, when you're a very small minority in that location? And African Americans at this time in Ohio were only about 1% of the population, and in Illinois, even a little bit less than that. And also Black men didn't have the right to vote. And so you have a situation in which Black people are really going to need white allies in order to get anything done. And even in the white population at the beginning, there aren't a lot of people who are going to be supportive of repealing these policies. And so this is the context, and this is the kind of situation that this first civil rights movement is facing. So what did they do? Oh, let me not go there yet. So one of the key ways that people took action, particularly because they weren't going to be able to get a lot of people elected to change the policy right in the state legislature, they did a lot of petitioning. And so just thinking back to the petition I showed earlier as an example of that, white and Black activists in this movement, usually working in separate organizations, petitioned the state legislature to repeal these laws. Now, these petitions anybody could petition. So that's the first thing. You did not have to be a voter to petition. You didn't have to be a white person. You didn't have to be a man. So anybody, man, woman, child, could actually start a petition and petition the legislature. Now, we might now be a little bit cynical about petitions, like, do they work? Who actually reads them? All of these online petitions that are circulating all the time. But back in the day, in the 1820s, 30s, 40s, there were very specific conventions and kind of rules around petitioning. A state legislature or any legislative body could not ignore petitions, in fact, or at least they weren't supposed to. So when a petition was received by a legislature, these petitions would be sent to a legislative committee. And these committees would often come back with reports. So it didn't mean that the committee was going to do what the petitioner said or favor what the petitioner said, but at the very least, they would have to pay attention. They would have to take the petition, and then they would have to report back on it. When a committee was divided, sometimes a majority and a minority report were issued. So in this movement, people petitioned the legislature constantly. Hey, you've got to repeal the Black laws. These laws are wrong. They are abusive. And the legislature, a committee, would have to come back repeatedly and say, here's what we're finding. And in Ohio and in Illinois, repeatedly, these legislative committees would come back and say, well, we think the laws should stay. We need to have these laws. They're important for protecting the public peace, they would say. Even when the petitioners didn't get what they wanted, which was most of the time, though, these reports help generate discussion and debate, and they use the media to get the word out. So sympathetic newspapers would then publish the reports of the legislature and criticize them. So to give one example, in 1835, the Ohio House of Representatives produced a report defending the Black laws of Ohio, saying they were necessary to maintain the public peace. The Boston-based abolitionist, William Lloyd Garrison, got a copy of the report and published it in his abolitionist newspaper, The Liberator, with a lengthy commentary saying how racist and horrible the Ohio legislature was for caring more about public opinion in Kentucky than about the rights of the victims of racial oppression. So you have an example here, and there are many examples that I found in my research of how even when they're not on the winning side, because this is a hard struggle and they didn't get victories right away, they're using a combination of petitioning, the reporting out of the legislature, and then the media to get the word out about their cause. Now, this book is in part about party politics, because in order to get change and get policies changed, you have to eventually get people elected. And so the activists that I'm writing about had to find a way to get their issue about repeal of these racist laws into the legislatures. And they need to find a political party that is going to be willing to take up this issue. The biggest success this movement had in the Midwest came in Ohio, where neither the Whigs or the Democrats, the two major political parties, so you had the Whigs and the Democrats. In Ohio, it was a very split state, and neither party was dominant. And this meant that the movement was able to use third-party organizing combined with the rising popularity of repeal of the Black laws to finally get most of these laws repealed in the winter of 1849. So this is the biggest victory at the state level that this movement had, and it came in Ohio. Now I want to switch to Illinois and talk a little bit about Illinois, because Illinois was a very different situation. And I don't know if you have seen this Illinois map from 1820, but I just think it's so interesting to see it, because part of what it shows is that white settlement and kind of the organization of the state happened first in the southern and western peripheries of Illinois. And this is how migration of basically white settlers came into the state from the southern part of the state, or in the case of along the Mississippi River, it was originally more settled in terms of Europeans by French colonists. So Illinois was very different from Ohio because it was entirely dominated by the Democratic Party. And the Democrats were the party that were least likely to favor repeal of the Black laws. But the parties weren't in close competition in Illinois. The Democrats were really, really dominant. Let's see. So the growth of Northern Illinois, and here you see that it's not been platted or kind of mapped out yet. And this is where Native people were living, and and so it's only going to be in the next couple of decades after 1820 that white settlement begins to come into the northern part of Illinois. So in the early 1830s, through a series of treaties with the US government, the Chippewa, Ottawa, Potawatomi, Ho-Chunk, and Menominee tribes ceded much of this land on the western shore of Lake Michigan to the United States. And this opened the way for more white settlement and some Black settlement in this northern Illinois region. And so pretty quickly after these treaties are made in the 1830s, more and more people flood into northern Illinois, and many of them are migrants from the northern part of the United States. And so they're coming in with different kinds of ideas, and this is going to create changes in the party politics landscape in the state of Illinois. Chicago and far northern Illinois became centers for abolitionism, and significant Black leadership emerged after the mid-1840s. Zabina Eastman was a newspaper editor from the Northeast who came to Illinois at the end of the 1830s, and in 1842 founded a paper called the Western Citizen in Chicago. And this was an anti-slavery newspaper that did many of the same things that people were doing in places like Ohio. So to give an example, the Western Citizen published this very short petition here that would have been cut out of the newspaper, pasted on a larger piece of paper on which people would then put their signatures as a petition, and then this would be sent to the Illinois legislature. And as you can see, this petition asked the Illinois House and Senate to pass a law granting trial by jury to all persons where liberty is at stake. That means for people who are accused of being fugitive slaves, and to repeal the law which justifies the imprisonment of persons without charges of crime, and to repeal all other laws which operate to oppress our fellow men on account of color. So again, like the folks in Ohio, they're identifying that racial discrimination before the law is wrong and we need to get rid of it. Black residents, particularly those who settled in Chicago, became increasingly vocal and increasingly organized. And many people have heard of John Jones and Mary Richardson Jones, whose stories are very, very well documented and who were truly remarkable people. Another person who was very involved and very prominent in his own time was a man named Henry O. Wagoner, who actually worked for Zabina Eastman and the Western Citizen. When he first arrived, he had been trained as a printer. So when he first came to Chicago, he worked for Eastman before setting out on his own to open a grocery and catering business. And there were many more Chicago African Americans who became very involved in the movement to repeal the Black laws in Illinois. Now, Illinois, instead of going in the right direction in the late 1840s and early 1850s, went in the exact wrong direction. Unlike in Ohio, where the state repealed most of its Black laws in 1849, in Illinois, to make a long story short, after creating a new state constitution in 1848, that sort of invited the legislature to pass a law banning Black migration into the state. Then in 1853, John Logan, a Democratic state representative from far southern Illinois, introduced and pushed through a measure that attempted to actually completely ban Black migration into Illinois. And this was one of the most kind of racially reactionary policies in any of the free states in this time period. Only Indiana in 1851 was the only other free state that had attempted to bar Black migration entirely, and Illinois followed suit in 1853. And the period of the early 1850s was a very scary and depressing time for African Americans in the free states. Not only did you have Illinois and Indiana trying to ban Black migration, but in 1850, the United States Congress had passed the Federal Fugitive Slave Act. And so many people, some very prominent Black leaders, including a man named Martin Delaney, argued that African Americans should actually try to leave the country, right? That there was no good future for Black people here and that the country was going in the wrong direction. Now, this was a kind of big debate among Northern Black activists at this time. Should we think about leaving? Is this country never going to be a place that we can really call home? Or should we stay and fight? And here I just want to I want to kind of go on a slight little tangent very briefly to talk about a web exhibit that I've been working on with a number of people at Northwestern. This exhibit hasn't been published yet, but we're going to be rolling it out at the end of February. And the exhibit's title is "We Will Plant Our Trees in American Soil, Creating Community and Fighting for Justice in Illinois." And we're writing about the contingent of Black activists in Illinois who met this moment and said, you know, we understand why some people might think we should try to leave the country, move to Canada, move to Haiti, but we want to stay and fight. People like Henry Wagner, John Jones, Mary Jones, and a whole host of other Illinois African Americans came together after this 1853 law was passed and organized a statewide political convention to kind of come together and make the argument to repeal the Illinois Black laws. And our website talks about that movement from the early settlements of African Americans in Illinois to how they came together and created this convention in Chicago in October of 1853. And just to give you an example, because I'm very proud of it and I'm really excited for it to come out. Within each topic on the left-hand side, we have a variety of different subtopics. So we have a topic called Foundations of Protest, and then we go to talking about founding independent churches, which were kind of hubs of organizing and of course, faith-based community as well. We talk specifically about women's organizing. We talk about the establishment of private schools for Black children, since they were barred from attending public schools in most places. And we also have this section on petitioning for justice in public education. And then we have a whole other section with subsections on Chicago itself. We have material on the Colored Convention itself of 1853. And we have profiles of 25 individual people, men and women, who were involved in this movement in various ways. And so this is just to give you a sense that we have been doing more research than what's in my book on the history of African Americans making community and getting involved in politics and calling for repeal of these repressive laws And then this is coming out again in a little more than a month. So I'm going to keep the Evanston History Center updated on this, and I'm really looking forward to hopefully to releasing it and the idea that it might spur more additional research on these kind of topics. Okay, so back to our story. So Illinois is a tough nut to crack in turn because of Democratic dominance in the state. But things are changing because of new kind of political configurations, new people moving into the state. And after 1854, when the leading Democratic politician in the state, Stephen Douglas, engineered the Kansas-Nebraska Act, many Democrats had had enough of their party and they were ready to leave their party. And a significant new party began to take shape, the Republican Party. And the Republicans had picked up and carried forward the ideas about racial equality in civil rights that the movement had been developing for a long time. So in short, the Republicans become the carriers of these ideas that these kind of racially discriminatory laws, these racist laws, even in free states, are unacceptable and need to be repealed. In the interest of time, I was going to talk about the Lincoln-Douglas debates and Lincoln versus Douglas's kind of views on these issues, but I'm going to skip over that. I'm happy to talk about it in the Q&A, but let me kind of wrap up. So as I mentioned at the beginning, in the book, I write about another, in addition to these movements to repeal the Black laws in the Midwestern states, I also write about this other thread that has to do with arguing for the rights under the United States Constitution of African Americans, particularly sailors who traveled across state lines. Bringing these threads together, what we can see is that on the eve of the Civil War, there was no federal way forward in terms of protecting people's rights. So all people were left to do was fight at the state level. They found that intensive political organizing and the right conditions could lead to repeal of these racist laws. But at the federal level, there were no protections for the basic rights of free African Americans, and there would not be unless something changed dramatically. And so in the last two chapters of the book, I talk about how that dramatic change came with the Civil War and Reconstruction. The Republicans sweeping to office in 1860, at which point 11 Southern states secede from the Union, and this gave Republicans tremendous power to reshape federal policy. These Republican politicians who might be well known to you, men like Salmon Chase, William Seward, Henry Wilson, who's a senator from Massachusetts, also the better known Charles Sumner from Massachusetts, all of them were on record as participants in this first civil rights movement. Okay, and so were many other Republicans in Congress, including the people who framed the 14th Amendment and the Civil Rights Act of 1866. These men, who were now at the center of power in the United States, had been influenced by the arguments made over decades by participants in this movement that racial discrimination, like in the form of the racially discriminatory laws of the Midwest, should have no place in American life. And they had the opportunity, because of the Civil War and the moment that it afforded, to change the Constitution and put that principle of no racial equality into federal law. Now, these measures, in particular the 14th Amendment and the 15th Amendment, did not solve the problem once and for all. And I think we're all aware of that. For one thing, the amendments went unenforced for almost a century. So we had these new constitutional amendments that stopped the states from having policies like the ones that we had here in Illinois. No longer could you have explicitly racist laws on the books in your state, nor could you enforce them when it came to civil rights or when it came to voting rights. The 14th and 15th Amendments to the Constitution changed that permanently. And yet those amendments went unenforced for almost a century afterwards. They were undermined by the Supreme Court and by people's white supremacist impulses to try to abridge the rights of people of color. But these amendments, the 14th and 15th Amendments, were also the constitutional foundation for the new civil rights measures of the 1960s that finally allowed the United States to begin to deliver on promises of greater equality and dignity for all people. So because we're thinking about the Martin Luther King holiday right now, I wanted to close with a quote from my book. When I was working on my book, I kept thinking about this quote. And so I ended up kind of ending the book with it. And it goes to the question of, what good is politics and what good does trying to change laws really do? When Martin Luther King was working on trying to get Congress to pass what became the 1964 Civil Rights Act, some critics often told him that it was impossible to legislate morality. They said, you're a minister, you should be trying to uplift people spiritually, you should be talking about people's faith, about people's morality, we should be thinking about education in the schools. And he insisted that we had to also focus on changing laws and changing public policies. And he said versions of this quote many different times. And this is the one that I captured in the book. It may be true that morality cannot be legislated, but behavior can be regulated. It may be true that the law cannot make a man love me, but it can keep him from lynching me. It may be true that the law cannot change the heart, but it can restrain the heartless. This is what we often do, and we have to do in society through legislation. So right now, as we again face a critical need for federal legislation to protect the right to vote, while democracy itself is at stake, I think we would do well to think not only about Martin Luther King Jr., but also about that longer ago movement whose members' steadfast activism against very long odds actually gave us the constitutional scaffolding for strengthening our democracy today. Thank you.
Thank you so much, Kate. That was so interesting. I apologize to those of you. We now are open at the Dawes or in a couple moments, so mask is on, so I apologize. We do. So we're gonna jump right into questions, if that's okay with you. I know we're going to be mindful of time. Amy Easington, would you like to oh, I see you're unmuted. If you might want to turn on your video, and you raised your hand about a question. Amy? Okay, I think maybe we don't have Amy. Maybe, well, since no one else has yet jumped on, I personally I'm a little curious, and Beset, I know why you had to, but can you tell us just a little, maybe a nutshell about the debates, the famous Douglas-Lincoln debates as they related to the civil rights movement?
Sure, yeah. So in 1858, when Lincoln and Douglas, had their famous debates, Douglas was on record saying, and he said constantly in those debates, things like, this is a white man's country. This is a country made for white men. He went so far as to say that when the founders issued the Declaration of Independence, they intended it to apply to white people only. Now, Lincoln, on the other hand, and this is in the debates, people who were more progressive than Lincoln in Illinois wanted him to come out and call for repeal of the Black laws. And that he did not do. And to the frustration of many activists, kind of to his left, what we call his left. But Lincoln, when he faced off against Stephen Douglas, did say, you're wrong about the Declaration of Independence. It was intended to apply to all people regardless of race. This was not a white man's country. This is a country for everyone. And so while he didn't go so far as to call for repeal of the Illinois Black laws, and I think he didn't do that because the Republicans were in the mode of trying to gather as large of a coalition as possible, and he would have been worried that that would drive people out of the coalition. The things that he said about equality were kind of middle of the road, supportive of what this first civil rights movement was trying to do. Now, the other thing that is interesting about Lincoln, once he gets into the presidency, His administration, now they're very constrained in what they can do because actually the president doesn't have all that much power under the United States Constitution and didn't then. But his executive officers, so for example, his attorney general, his secretary of state, they did as much toward promoting racial equality before the law as they believed they could constitutionally do. And I think that's also very interesting. So for example, his attorney general, who was absolutely not a radical, issues an opinion at the end of 1862 affirming that African Americans are citizens of the United States. His State Department recognizes Haiti and Liberia as countries for the first time as independent countries, which means that they are going to send diplomats of African descent to Washington to participate as equals in the diplomatic corps, something that no administration had ever done before. And so in a variety of ways, the Lincoln administration does take steps to implement this vision as far as they think is constitutionally possible. Yeah.
Thank you. Okay, I have a couple questions that I'm going to read from the chat. Mark Hilton says, I assume you talk about Elijah Lovejoy, excuse me. Can you share your thoughts on his travails?
Yeah, I don't have particular thoughts on Elijah Lovejoy. I mean, his murder in Alton was one of these things that actually really galvanized a lot of Northerners who might not have otherwise cared very much about slavery, because the murder of a white man for simply expressing his opinion was something that a lot of people thought was really over the top, right? Showed this kind of mob violence and mob rule that a lot of white people didn't approve of, even if they have very strong feelings about slavery. Another interesting thing is an editor named Benjamin Lundy, who was a nationally known anti-slavery editor going very far back, moved to Illinois after Lovejoy was murdered to kind of keep the movement going in Illinois. But Lundy was pretty old by then. And then Zabina Eastman, who later becomes this really important editor in Chicago, moves to Illinois to help Lundy. Lundy passes away soon after Eastman got there. And so Eastman kind of takes over as the main anti-slavery editor in Illinois. So there's a kind of indirect link between Lovejoy's murder and Eastman being in Illinois and running the Western Citizen newspaper.
Okay, I'm going to ask somebody who raised their hand. Mitchell Harrison, did you have a question you wanted to ask on behalf?
Yeah, thanks. Maybe more of a comment. Wow, Kate, this takes me back to sitting in your lectures in the continuing education. People like you and Kevin Boyle. Oh my God, you're amazing. It's always fun to hear you talk. So intelligent. I learned so much, and I'm excited about reading your book. So this was one of the the best days of the year so far, and really enjoyed it. I'd like to hope to see you again soon.
Thank you so much. I really appreciate it.
Thanks, Mitchell. I think he speaks for a lot of us. Thank you. Can you tell us what impact you think Andrew Jackson's election in 1828 had in our progress away from overtly racist laws, or maybe towards? I don't know.
No, I would say none at all. Again, for a variety of reasons, presidents are not that important in my study until we get to the Civil War, because the president didn't have that much to do with this stuff. I mean, it was up to states. And this was a fact of kind of American history from the founding until Reconstruction, that Andrew Jackson, didn't directly have anything to do with what Illinois decided to do as legislation or Georgia or whatever for that matter. And so, part of the struggle here and part of what we're still struggling over is to what extent the federal government can be involved in the matters involved in the states when it comes to individual rights, right? And right now, I mean, to be really frank, right now, what's at stake in the voting rights legislation that's being discussed in Congress has everything to do with the distinction between envisioning a larger federal role for being able to put a kind of floor on how far states can go to stop people from voting. The Democrats want there to be more federal involvement to say, there are certain things states cannot do. And what the Republicans are defending is a world in which the US government doesn't get involved with that, and the states have just about as much autonomy as they want. And so, in these areas, I mean, the federalist structure of the United States is very interesting. There are some good things about having so much power devolved to the states, but in certain issues related particularly to race and rights, we have there's a pretty big kind of challenge and a pretty big issue with having so much power to the states. Anyway, with Andrew Jackson, Andrew Jackson, I was just teaching a book. It's actually a wonderful book called Unworthy Republic by Claudio Sant about Native American history in the 1830s during Jackson's presidency. Jackson wanted to push all the Native people who lived east of the Mississippi River to west of the Mississippi River. And his administration was overtly racist, kind of promoting ideas about white supremacy, not only when it comes to slavery, which he was a large slave owner, but also in relation to Native Americans. And one of the things that's interesting about Claudio Sant's book is how many people opposed Jackson. I mean, there were huge, the federal Indian removal legislation passed by only 5 votes. If 5 legislators in Congress had voted the other way, we wouldn't have had that policy. And so, I think that's one of the things I'd really like people to take from this book, is that these struggles in the United States have often been very close calls. And it really matters when people stand up and stand up for what's right, because, sometimes it comes down to a very close call, and each person, doing the right thing really makes a difference. Anyway,
Okay.
sorry, tangent.
No, that's wonderful. I think we have maybe time for one more. There's actually a question that's almost more of a comment that I'm going to read and see if you have an answer in there, and if not, there's one other question. And I know there are others, and I apologize to everybody. So Al Cubbage tells us, you mentioned the Northwestern Ordinance of 1787, which created the Northwest Territory, for which Northwestern University is named. That ordinance prohibited slavery. Whoops, I got to get down. My mouse.
I can read, yeah.
You can read, okay.
How did an ordinance that prohibited slavery in such a vast territory get passed into law? Yeah, I mean, it's an interesting question. I think most historians would tell you that there were many different impulses coming out of the founding of the United States. Some were very pro-slavery, some were pretty anti-slavery. And so, there's a big debate going on right now about, it probably always is this debate going on about to what extent is the Constitution a pro-slavery document. I think the Constitution could have been a lot worse, and it could have been a lot better. And so, the Constitution could have more directly supported and affirmed slavery and the right to own human beings as property, and it did not do that. But the Constitution could have also abolished slavery or set slavery on the road to abolition, and it didn't do that either. So where did the Northwest Ordinance come from? It came from the impulses within the founding of the United States to say, we actually want to see slavery, go by the wayside eventually. Yeah, and it's really important that that passed as a federal measure.
Okay, this is going to be our last question, and we might be able to get it in, squeeze it under the. This is from Jeremy, who thanks you for a wonderful presentation today. He says, today issues of race seem tied, not totally to urban-rural divide. Curious if there are similar dynamics in Illinois and the Midwest during the period of the first civil rights movement.
Yeah, good question. I would I would say yes and no to that. There's, just to be very brief, the Cincinnati emerges as a very interesting place in this book, because even though it's right next to Kentucky and on the Ohio River, and there's a lot of pro-slavery stuff going on. There are a lot of slave owners who come into Cincinnati to do business and go back over the river kind of day in and day out. And yet a very strong anti-slavery newspaper emerges there. A very organized and kind of amazing free Black community develops there in Cincinnati, and that partly has to do with it being a city. Chicago is really different. It is a very anti-slavery city at this time, but it also is much further north in culturally and in many different ways from Cincinnati. So it's less surprising to find that. But there were a lot of very anti-slavery rural white folks also. And that is a kind of, that needs to be put in the hopper. There were church congregations. A lot of times, churches actually divided. So denominations, Baptists, Methodists, white Baptists and Methodists divided over the extent to which they were anti-slavery. And there were rural areas in Illinois, for example, that were known as places where anti-slavery white people lived, where they had churches that were anti-slavery, where they supported the Underground Railroad, and things like that. And then other pockets of rural Illinois that were known to be virulently racist, very, very anti-Black, places where Black people, sundown, that it becomes sundown towns, places where Black people would know they shouldn't pass through. So there's not I wouldn't reduce it to a rural urban divide, but there is some interesting stuff going on with cities in this period. Yeah, thank you so much. This has been such a pleasure speaking with everyone.
I think we all learned a lot. Definitely things, aspects we thought we knew that we don't, or we didn't. So I look forward to hearing much more and reading the book and learning. And we will be sharing the website. When Kate shares it with us, we will share it with the people on the call. So thank you all so much for attending. Thank you, Kate, for a fascinating program, and we'll look forward to seeing the results of the website.
And listen, just because
exhibits.
It's such a low, you guys are, this is my community, so please feel free to reach out to me on email. It's kmasur@northwestern.edu. If you have questions or want to talk to me about anything, I'm really happy to hear from folks. Thanks so much.
Thank you, everyone. Bye-bye.
Bye.